If you've just been named as an executor in Texas, you may be asking yourself, where do I even start? Don't worry, you're not alone. Today, I'm breaking down the top 10 questions about executor duties in Texas. In part 1, we'll cover the first 5 steps every executor needs to know. I'm Jennifer Nichols with J. Nichols Law. We help families across Texas navigate probate and estate planning so they can feel confident every step of the way. Be sure to subscribe and follow us so you don't miss part 2. Question number 1. What are the primary responsibilities of an executor? In Texas, the executor is the person the court authorizes to settle someone's estate. That means paying off debts, safeguarding property, and distributing assets according to the will. Executors must follow Texas probate law closely. They are legally accountable for handling everything properly. Question number 2. What steps must the executor take to notify beneficiaries? After you're appointed by the court, in most cases, Texas law requires you to give notice to the beneficiaries named in the will. This isn't just a courtesy, it's a legal obligation. Unless an exception is met, you must give written notice to each beneficiary named in the will. Notice must be sent by certified mail within 60 days after the will is admitted to probate. Proof that these notices were sent, typically in the form of a sworn affidavit, must be filed with the court within 90 days of the will's admission. Exceptions include beneficiaries receiving $2,000 or less in aggregate assets and beneficiaries having already received all the gifts they are entitled within 60 days. It is also a good idea to keep beneficiaries reasonably updated on the progress of the probate administration. Keeping communications clear helps avoid disputes later. Question 3. What steps must an executor take to notify creditors? In Texas probate, an executor must take specific steps to notify creditors about the probate. The process is governed by the Texas Estates Code and involves both published notice and direct notice to certain types of creditors. Within 1 month after qualifying as executor, you must publish a notice to creditors in a newspaper of general circulation in the county where the probate is pending. The notice should say that persons with claims against the estate should present them and provide the executor's contact information. Within 2 months after qualification, you must send written notice by certified or registered mail to all creditors holding claims secured by estate property. For example, mortgages and car loans. Proof of mailing and an affidavit must be filed with the probate clerk. Executors may, but are not required to, send written notice to known unsecured creditors, such as credit card companies. If sent, this notice gives the creditor 4 months to submit their claim in proper form, or it is barred. Question number 4. How does the executor locate and secure the deceased person's assets? Executors are responsible for finding and protecting all estate property. That can include bank accounts, vehicles, real estate, retirement accounts, and even personal belongings. Ideally, the executor was close to the decedent and knew about all of his or her assets and accounts. In this case, the executor just has to secure the assets. In cases where the executor does not know about the decedent's assets, the executor should review the decedent's personal records, mail, financial statements, tax returns, and digital files. This will help him or her find evidence of bank accounts, investments, real estate, retirement plans, insurance policies, business interests, and debts. To secure the financial assets, the executor should notify the decedent's banks and brokers to let them know the decedent has passed away. The physical assets also need to be secured. Depending on who has access to the decedent's house and other properties, the executor may want to change the locks to prevent unauthorized access. The executor should also prevent the estate's vehicles from being driven until the title is properly transferred. Question 5. What is an inventory, appraisement, and list of claims, and when is an executor required to file one with the court? An inventory, appraisement, and list of claims, also known as the inventory, is a sworn document that a Texas executor must prepare. It lists all probate assets owned by the decedent at the time of death and states their fair market value as of the date of death. It should include a separate listing for each titled asset, but non-titled personal property can generally be lumped together in a category called household goods and personal effects. The inventory also includes a list of claims. That's amounts owed to the estate, such as refunds, last paychecks, or promissory notes payable to the decedent. While the executor is required to prepare and sign a sworn inventory, he or she is not always required to file one with the court. In cases where there are no unsecured debts and the executor has sent the inventory to the beneficiaries of the estate, the executor can file an affidavit in lieu of inventory. This is desirable so that the assets of the estate don't become public record. The inventory, or affidavit in lieu of inventory, is due to be filed with the court within 90 days of your appointment as executor, unless an extension is filed and authorized by the court. So those are the first 5 of the top 10 questions about executor duties in Texas. In part 2, we'll go over the next 5, including what to do about debts, taxes, and distributing assets. If you've been named executor, or you're planning your estate and you want to make sure your family has a smooth process, J. Nichols Law can help. Reach out to us for a consultation and we will guide you through every step. And don't forget, subscribe, follow us on Facebook, and stay tuned for part 2.